If there's no objection, the journal of proceedings of the trial are approved to date. Pursuant to the provisions of Senate Rule 16, Resolution 16, the counsel for the president have 18 hours and 9 minutes remaining to make the presentation of their case. The Senate will now hear you. The presiding officer recognizes Mr. Counsel Kendall.
Mr. Chief Justice, members of the Senate, managers from the House of Representatives, good afternoon. I'm David Kendall of the law firm of Williams & Connolly, and since 1993, it has been my privilege to represent the President in the tortuous and meandering Whitewater investigation, which approximately a year ago was transformed in a remarkable way into the Lewinsky investigation. The evidence plainly shows that the President did not obstruct justice in any way, and there is nothing in this article which would warrant his removal from office. As I begin, I want to thank you for your open minds, for your attention, for your withholding judgment until you've heard all of our evidentiary presentation. There are a lot of myths about what the evidence is in this case. Some of them are misunderstandings based upon erroneous media reports. Some spring from confusion in the evidence itself, and some are the result of concerted partisan distortion. I want to talk to you this afternoon about what the record is and what the evidence actually shows. And I apologize to you in advance if the process is tedious. What I think I've got a request from you is your common sense and some uncommon patience. But the evidence, those stubborn facts, are critically important to inform your ultimate vote on these articles. I'll do my best to avoid repetition and lawyer talk, although I am a lawyer.
Welcome back to For the Defense. My name is David Oscar Markus, and what you were just listening to was David Kendall during the Clinton impeachment proceedings in the late 90s. It's such a pleasure for me to have David on the show today. During that time, I had just finished my clerkship and was working at my dream job at Williams & Connolly. So this is really sort of a full circle trip for me in getting to interview him about those proceedings and about that time. You're going to hear from David, who's such a charismatic, smart, wonderful lawyer, tell so many great stories and bring us back in time to those impeachment proceedings. And you'll hear about the repercussions that they really have on today's proceedings during impeachment and other things that are going on. So thank you, David Kendall. We're back on For the Defense now, talking about Clinton impeachment. Next. I'm really excited today. We have David Kendall from the law firm of Williams & Connolly here. Welcome, David, to the show.
Thanks very much, David.
So David, I worked at Williams & Connolly back in the 90s as well, and this time period with the Clinton impeachment and so many other things going on, really exciting time. But before we get there, I want to talk to you about your time before Williams & Connolly. You started out clerking on the Supreme Court with Byron White. Tell us about that.
I clerked for Justice White in 1971 to 1972, the October 71 term, to be technical. And it was right after law school. It was a very exciting experience. Justice White had been a clerk himself. He was centrist, I would say. He often voted with the conservative wing of the court, sometimes with the liberal wing of the court. But he understood the process. He was just terrific to law clerks. He played basketball with the law clerks as well, and he'd had 12 varsity letters at the University of Colorado. Most famous for his football career. He spent 2 years in the National Football League. And we joked when we played basketball with him that we weren't sure he knew the difference between football and basketball because he was very aggressive. but fun to play with, and played with decades younger clerks. So it was a good year. There were many interesting cases. The death penalty cases, first round of them were that year. The abortion cases were argued but not decided then. The newsman's privilege case was argued, and there were several others.
The highest court on the land. It's one of my dreams is to see that basketball court.
It is truly, it's an insider joke, but the highest court in the land does exist. And according to Justice White, he clerked for Chief Justice Vinson after he got out of the Navy and law school in World War II. And apparently they were playing during hearings, and Chief Justice Vinson set up a note saying, "Stop playing. We can hear vaguely the pounding of the basketball on the roof of the courtroom." So we couldn't play during the time the court was in session.
That's great. And famously, David, and I see it on your bio on your website, after you clerk, you were doing some voting rights stuff. And was it after or before that you get arrested with?
That was actually before. It was during college, between my sophomore and freshman years, in the summer of 1964. I was part of the Mississippi Freedom Summer Project, which was an attempt to use college students, basically from the North and the South, black and white, to try to register voters in Mississippi. It was before the Voting Rights Act of 1965. It was very tough. And I was driving a Volkswagen, and I got arrested a number of times. I didn't keep a record, and I was always worried that, the bar exam, you have to report arrests, not just convictions. So I usually would say, from 10 to 12, but I don't have exact records. I was only convicted once, though. And that was for driving without an inspection sticker, of all things, which I had to plead guilty to.
That pretty good record, though, if 11-1 for criminal cases in college.
Well, I had good lawyers, but also these arrests were usually just harassing arrests. I'd never found the basis of this, but in Mississippi, it was thought you could be held for 3 days without charges being filed. So often I was simply released.
Good trouble that you were causing. I love it. And then after you clerk, you do handle some death penalty cases yourself and end up arguing in the Supreme Court a death penalty case. That must have been quite an experience.
Well, it was. After the Supreme Court, I owed the Army time, and because they had too many second lieutenants, it wasn't the full 2 years. But after the Army, my wife and I went to New York, where I had a job with the NAACP Legal Defense Fund as a staff lawyer. Enough time had elapsed so I could work on death penalty cases, although no cases which had been there when I was a clerk, but there weren't any. So these were all new death penalty cases. And the states had rebounded. The Supreme Court on June the 29th, 1972, in a case, it was really 4 cases called Furman versus Georgia, 5-4 majority of the court had outlawed the death penalty as then imposed. And the justices had a variety of rationales, but the 2 middle votes were Justice Stewart and Justice White, who took the view that the death penalty was simply too freakish in its imposition to justify the extremity of the punishment. And it just wasn't clear that the states were really serious about it. So the states rebounded in 2 ways. One, by enacting mandatory death penalties, sometimes narrowing the homicide offense, but making the death penalty mandatory. Others by, as Florida did, enacting a bifurcated trial situation where the first part of the trial is to find out simply guilt or innocence as to a potentially capital offense. Then if it's guilt, then there's a second stage at which mitigating and aggravating circumstance evidence is admitted on the issue of sentence, which would have been, of course, inadmissible on guilt innocence. So those were the 2 kinds of statutes we were challenging.
And you're successful in the case that you argue, which must have been such a thrill.
Well, yes, I'd have to qualify that, though, because we challenged death penalty for murder in across the range of those 2 different kinds of statutes. We lost the aggravating mitigating circumstances statute in a case called Profit versus Florida. The court upheld the Florida statute by 6-3 vote, and as I recall, but they did strike down. I represented two people in one in Louisiana, one in North Carolina, and won that case. Tony Amsterdam argued it, but won on the mandatory death penalty. Then they've been holding in abeyance maybe 5 or 6 cases in which the death penalty had been imposed for the crime of rape, in which the life of the victim had not been taken. And the death penalty for rape has a particularly unsavory history, as I'm sure people know, about being racially imposed. So I represent all, at the time, I filed cert petitions on all 5 of the people on death row for rape, 4 of whom were black, 1 was white. When the court brought down its death penalty rulings, or maybe it was slightly after, it granted cert on the question whether the death penalty for rape, when the victim's life was not taken, was violative of the 8th Amendment's ban on cruel and unusual punishment. The case they chose was the one white death row inmate, Ehrlich Coker. And so he was on death row in Georgia. And this is a case that I did argue in the Supreme Court myself in March of '77.
And you won.
Won. And I still represent Mr. Coker. We just filed and were denied. Well, no, we got it rehearing, so it's still pending a petition for clemency. He has been on. He wasn't he was resentenced to life imprisonment, but not without parole, life without parole. So he's technically eligible for parole. He keeps coming up. It keeps coming up, and it keeps being denied. But we're in hopes that he's now spent 51 years behind bars for his crime. I'm hoping that we can
Wow.
get him paroled for the rest of his life.
What a saga. And then of course you go work for the powerhouse Williams and Connolly. And when I was there, I never got to meet Edward Bennett Williams. He had already passed by the time I had joined the firm. Any good Williams stories for the podcast before we get into the Clinton stuff?
Well, he and Tony Amsterdam are the best lawyers I have ever known. Tony, because of his appellate skills and some trial skills as well. Ed, largely because of his trial skills, but both are geniuses. Ed had a saying that there are only 3 secrets to successful litigation: preparation, preparation, and preparation.
Right.
And doing a case for Ed was, and I went to trial with him 3 times. He would start when the client came in. On one of these, I was there when the client came in. He'd keep notes on a soft lead pencil, large yellow legal notepad, and he began taking notes. And I finally asked him, the second or third meeting with the client, I said, Ed, I'm taking notes. I'm typed up. What do you do? He said, well, I'm planning my closing. He would go into a cases I had with him, thinking about what he was going to say on closing. And amazing. he would strike out stuff as new facts emerge, and he would change it. But he always had in mind what narrative he was going to try to pursue. And he was very intent that cross-examination, and I was able to cross-examine some witnesses in his trials. He did most of the work, I would have to say. But his rule in cross-examination was no shaking the Christmas tree, and always have a goal in mind and only get what you need and be careful, but no kind of, and he liked short cross-examinations. So at one point though, we had a trial and he was cross-examining this banker up and down and making this poor banker just to answer all these questions, many of which he couldn't answer. So at the break, I said, Ed, why did you torment that guy? He's really not a key witness. And Ed laughed and he said, that banker was arrogant and he was wearing a rug. And people hate bankers who wear rugs. And that was a little bit of insight that I've always taken with me. But I've never met a banker wearing a rug yet on cross-examination.
I love it. All right. So you end up representing Bill and Hillary Clinton, obviously. and you had been representing them in the Whitewater investigation when the investigation sort of metastasized. But how did you get involved in that and representing them in the first place?
Well, this began back in, I've got to get my years right here, 1993. The president had been elected in November of 92. His administration had faced a number of controversies in early 93. His Deputy General Counsel, Vincent Foster, who'd been one of the First Lady's law partners in Little Rock, committed suicide. And that was a tumultuous event, largely driven by, sadly, his depression. And at the time, the Eagleton stigma was still there about admitting to depression and seeking treatment. And anyway, it was a tumultuous time. During the campaign, rumors had surfaced about a very small land development company in Arkansas that the two Clintons had partnered with Jim and Susan McDougal. And McDougal was kind of a savings and loan entrepreneur. He was a populist banker. And it was a very small company, but there were rumors about it, unfounded, but everybody, the press was in search of the new Watergate. Right. And they were convinced that Arkansas was rife with corruption. This was it. The McDougals, after forming this company with the Clintons in 1978, had gone on in 1982, the McDougals only, not the Clintons, to acquire an S&L in Arkansas, the Madison Garrity S&L. And it, like many S&Ls, after deregulation, thank you, Messrs. Garn and St. Germain, right. It had run into problems. And the Clintons weren't involved, although Hillary did a little bit of work for the S&L, just regular lawyer work when she was at the Rose Law Firm. But there was supposedly a big scandal regarding the Whitewater Development Company. Now, that had come up in the campaign of 72. It had been put to rest. The Clinton campaign hired a very good lawyer in Denver named Jim Lyons, and he did a top-to-bottom report and said, there's no there, and it made it public, and that it went away. But in the fall of 93, the RTC, which was the, if you recall, those lawyers old enough to recall will recall that after the S&L kind of debacle in the mid-late 80s, after the 88 election, both parties didn't want to touch this before the 88 election. An agency, the Resolution Trust Company, was set up to administer the assets of the failed S&Ls. Right. Ultimately, spoiler alert, the RTC sold most of those properties, and really a lot of the properties turned out to be profitable because the RTC could hold it. But anyway, there was an investigation looming. And on October 31, a day I remember distinctly, 1993, the Washington Post ran a headline story about something about Whitewater Development Company or Clinton Company wrapped up in S&L scandal. And later that week, I got a phone call asking if I would come over. The Clintons, it was clear, were going to have to give testimony, even though there was no there, they were going to give testimony. So I was called to the White House, and I was interviewed by Bernie Nussbaum and a couple of other people. And I think there were 3 or 4 people they were looking at. I was chosen, I think, because of 3 things. One, I'd been dealing for the last few years with a lot of S&L stuff, representing S&L owners, lawyers, accountants in both civil and criminal proceedings and in administrative investigation. That was point 1. Point 2, I had known both of the Clintons in law school. The First Lady much better than the president, because the First Lady and I had overlapped 2 years. I only overlapped 1 with the president, but I contributed to his gubernatorial campaigns. He was a fellow Rhodes Scholar. And I had, every now and then, I would talk to Hillary, or Hillary would talk to me about getting legal representation on. She was a very good lawyer in Little Rock. And so we would talk about that. And then third, my partner, Bob Barnett, who was a super lawyer. He was a clerk for Justice White a year after I was. He's one of the reasons I came to Williams and Connolly. Bob was representing the president's mother, President Clinton's mother, in doing a book. And I learned later that Bob was describing me to all who would listen as a cross between Edward Bennett Williams, Clark Clifford, Oliver Wendell Holmes, and Louis Brandeis.
That's pretty good.
And so yeah, I was a paragon in his telling of legal virtues. So I was hired and investigated, and that was the way it started. And we went through independent counsel Bob Fisk. It's a long story, but Bob Fisk first, and then Ken Starr was appointed in August of '94.
Well, I want to ask you about Ken Starr, of course, and the independent counsel, because, of course, as you say, this starts out with Whitewater. By the way, we had Mark Garagos on the podcast, who represented Susan McDougal. Had some great stories about
very good lawyer. Mark is a hero.
Yeah, no, had some great stories about that case. But so Ken Starr comes in, but to investigate one thing, and it sort of just sprawls out and spreads like a virus, which should we have these independent counsels, David? And now that, which is slightly different, the special counsel, there's been so much criticism of how they start with one and spread, and they're looking at one particular person, which is very odd for a prosecutor's purpose to look at a particular person. When that's your mission, of course, you're going to find some stuff.
Well, you're right. The point I'd like to make is that Starr was operating under the Independent Counsel Act, which was a statute passed as part of the Ethics in Government Act of, I believe, '78. Now, can you imagine, as a congressman or a senator, voting against something called the Ethics in Government Act? It'd be hard. It set up a sort of special agency, and the Supreme Court upheld that. The dangers were that unless you are very disciplined and have prosecutorial experience, you are likely to wander in the wilderness because there's no control over you.
Right.
And you, as you say, and as Justice Scalia said in his dissent to the upholding the statute, a prosecutor has only one goal in life: to look at you. Now, look at you, the putative defendant. The reason you want to do that, it's a legitimate reason. You don't want politics to be put on the thumb of a decision to prosecute or not to prosecute. And for many years, I must say, the independent counsel were experienced. They knew that their job was to get in. If there's something indictable, indict it, try it. But if there's not, get in, get out. Mm-hmm. And getting out took some, nerve but the credibility. And I think Bob Fisk would have been a very different independent counsel than Ken Starr, because Fisk was a experienced trial lawyer. He'd been U.S. attorney and tried cases, and I had to deal with him for 6 or 7 months, and he was tough. And but he knew, I think, that there was no there. Ken Starr, very smart lawyer, and I'd known him, and we'd had congenial relations for a number of years. But he was an appellate lawyer. He had no line criminal experience as a prosecutor ever. So he had to learn on the job. And I think that was one of the problems of the office. Also, I think Starr's view of the office was much more of an investigative. He was much more of a truth commission kind of lawyer than a prosecutor. And people who've been prosecutors know that your job as a prosecutor is to see in secret, collect evidence, make a fair judgment as to whether you've got enough evidence to convince a jury beyond a reasonable doubt. And that's it. And if you don't, no matter how sneaky, bad you think that the target is, you don't indict.
Right.
And I don't think that lesson ever was internalized at the independent counsel.
So, obviously Starr's mission was investigate over here, and then all of a sudden it spreads, and as big as the Whitewater investigation was, it sort of pales in comparison to what happened with Lewinsky. How do you find out, David, that they're looking at the Lewinsky matter, and how does that news break?
Well, it I should say something about my duties as opposed to counsel defending the Paula Jones case. Paula Jones was an intern in Little Rock who claimed that President Clinton had harassed her
right
before he was in the White House. that was a civil case, and the White House elected to have Bob Bennett defend that. Bob was more vocal in the press than I felt comfortable in being on the Whitewater stuff. But anyway, and that was a choice, and they defended that case. I began to get, in years are important here, in 96, the Whitewater investigation spawned a congressional investigation, and we fought. It was just a kitchen sink battle there with Congress, but we had allies as well. And, it became clear that there was nothing there.
Right.
And when there was a lot of publicity about the investigation, the Republicans recaptured Congress in 94 in the Gingrich wave. President Clinton always referred to what Gingrich was doing as the contract on America, contract for America. But
that's great.
In any event, we defended that. And by the end of the day, in June of 96, when the committee issued its Whitewater report, it was on page, I think, 7 of the Times and maybe page 8 or 9 of the Washington Post. There really was nothing there.
Right.
Starr tried to resign after the election. President Clinton defeated Senator Dole, and in January or so of 97, I got my phone began to light up with calls, which is never a good sign. But it was that Ken Starr had resigned, and indeed he'd submitted his resignation and I don't remember, it was January or February of 97, basically saying it's over. There was such an outcry, though, in the conservative press saying, oh, he can't walk away until he's really gotten to the bottom of this, whatever this was. So he unresigns 3 days later. And that was a tip-off to me that, this was not going to be a walk in the park if I'd ever thought that, which I hadn't. But anyway. So in about June of that year, the Supreme Court came down with this decision saying that the Paula Jones case could go forward. Right. And alas, that meant discovery. And so, but that was conducted by the Skadden Arps team. Anyway, I began to get word that Starr's investigators, and this is June of 77, were investigating reports of the president's alleged relations with various women. So I wrote a sharp letter to Starr saying, I don't know if these are true, but if these reports are true, you've got to stop it. You have no jurisdiction. This is harassment. You name it. I said it. Okay. And I really got no response. But the reports kind of died down. And since this was in the context of discovery in Paula Jones' case, I thought, well, maybe these reports are coming out of that. I thought no more about this. We had a number of controversies to wrap up. The Clintons testified. I believe each of them testified 5 or 6 times to Starr before 1998. In 1998, the president's deposition was scheduled. And as we now know, his deposition was going to be taken on Saturday. On the Monday before, Linda Tripp had called the independent counsel. Linda Tripp, again, these names, I don't know if your listeners are familiar with them. Linda Tripp was the supposed friend of Monica Lewinsky.
Right.
And Linda Tripp said, there's this wrongdoing going on involving this White House intern. So Starr's people had Linda Tripp tape her secretly. And then on Friday before the deposition, the next day, they took her into custody at the Pentagon Mall food court and took her into I think it was I'm trying to think of the name. It was a swanky hotel there. They held her there for 8 or 9 hours and braced her and tried to get her to talk. Anyway, the deposition was scheduled. Of course, I was, in New York having a good time that weekend. And there were rumblings after the deposition that weird things that Paula Jones' team was celebrating lavishly that Saturday night. And I thought, well, that's just they're just trying to, kind of make a show.
Right.
Then I got a phone call on Tuesday, night after the deposition from White House counsel Mike McCurry. And Mike had not, they'd split off the Whitewater Monica stuff to another group in the White House, but Mike was his press secretary. And he said, I'd like you to be aboard on a 9 p.m. call of the crisis group. And that was a senior aides. And I said, yeah, fine, I've got some people here, I'll stop drinking wine then and flip phone in. And so at 9 o'clock, I said, Mike, what's the call about? He said, well, the Post is going to run its Monica Lewinsky story. And I said, in words that I still remember, Mike also remembers, Mike, who's Monica Lewinsky? Well,
Right.
he told me. And so we had the call, and I said, look, I think there's got to be a mistake. Starr clearly does not have jurisdiction here. I don't know. Let me check this out, because I think the Post is wrong. I'd represented the Post before on a lot of things, but I didn't, not in this area certainly. But I said, let me do this. I think the thing to do is to go first to the DOJ, because the Post was allegedly going to run a story that said Starr's jurisdiction had been expanded.
Right.
So I placed a call to the DOJ, and it went to the command center. They're very efficient, and I was seeking to talk to the deputy AG, Eric Holder, and very good guy, straight guy, and I got him in a Wizards basketball game, and so he said, "Let me step out." He steps out in the hall, and I said, "Eric, look, I think that the Post is barking up the wrong tree here. I really think that you guys ought to try to shut this down. We certainly are, but we don't have the inside knowledge. They're gonna say that the independent counsel's jurisdiction has been expanded by the Attorney General to encompass the Paula Jones case." And there was a pause, and he said something like, if I were you, I wouldn't get too far out in front of that one. Now,
Wow.
he had not said anything to betray any knowledge, but it was to those with ears to listen, and I had two. It was, back off on that one, and don't try to go down up that tree. So I report back, and they say, well, okay. Then there's a report about 10:15 that the first edition of the Post has come out, and there's no Monica Lewinsky story. So I help my wife with the dishes. I go to bed, and then at about 1 o'clock, I'm awakened by a call from Chuck Ruff. White House counsel has been on the other call, saying the Post's story is in the second edition. So then we were off to the races, and it was really a new day. And I think because the independent counsel had not closed down when it should have, but kept hanging on in the hopes of getting something, there's finally a time where they thought they had something.
And so, David, I know, and you mentioned this before about you not being a guy who's out in front of the press, and Williams and Connolly, is famously known for not being, out in the media a lot. Obviously this is in the Post now. What's the thinking about how you're going to deal with the press, how you should deal with the Lewinsky matter, because obviously it's now front page news and everybody's running with it?
Well, we put out a denial. We thought that the White House team was better equipped to do that. And then I started investigating, because this was all new to me. And Skadden was now, who'd been representing the president in the Paula Jones civil suit, was, I think, feeling in the crosshairs a little, because they're alleging obstruction of justice. They're alleging that the use of the Lewinsky affidavit at the Clinton deposition was false. It was potentially objective. So we had to take over the entirety of the Lewinsky defense, or the defense on the criminal investigation. That meant getting people lawyered up. It meant trying to figure out what the facts were. And that was a kind of full-time operation. So also we were dealing now with subpoenas from the independent counsel for this, for that. And Starr began writing me in about 3 weeks seeking the president's testimony. And that sparked an exchange of letters that went on for about 6 months, which as I read them are funny kind of in a way, because he's saying, President wants to talk. How about next Tuesday? And I would say, well, he can't, he's going to Europe. But and it went on. And then they began leaking like crazy. And I filed a 6E proceeding before the grand jury judge, which was in secret. I mean, the actual proceeding was in secret. I announced that I was filing it, and that held them at bay for a little while. So that it was a very, I don't remember with any pleasure at all anything that happened in those. Well, I don't remember anything pleasurable about 1998 at all, except maybe the first week of it.
Well, David, you weren't, doing all the news shows, but I did see Saturday Night Live had someone play you on their show. This guy Chris Kattan played you on SNL. Did you see that?
I didn't see it, and I now that you say it, I do have a recollection that people may have mentioned it, but I didn't see. I wasn't paying attention. I mean, I was paying attention to the press insofar as there would be something about the investigation, but the human interest side had no human interest for me.
Right. So, you mentioned Newt Gingrich, comes to power in this sort of wave. And he was out there predicting that, the House proceedings was going to lead to Republicans taking over the House in a landslide. It sort of backfired. Looking back, it looks like the Democrats picked up seats and Gingrich ended up resigning over this whole thing. I mean, did the Republicans sort of overplay their hand on Lewinsky?
Absolutely. I think for a variety of reasons. And I should add that we're all talking about 1998 now. This controversy began in January. We worked through a number of things, including the president's testimony in the grand jury, the Starr reports released, the release of the president's interview by the independent counsel. By the time of the election, Gingrich was indeed making predictions. As I recall, he said, we're going to pick up 22 seats in the House and we're going to take control of the Senate. Well, the result, as you've said, was that in the November midterm elections, and remember, this is midterm of a second term of a president, when usually the incumbent party just takes a beating.
Right.
Here, the Dems picked up. They didn't lose seats in that. They picked up 5, and the balance in the Senate remained the same. So it was politically a disaster. And it was interesting. The Lewinsky matter moved on both a political and a legal track. And I think probably the political track was much more important and finally significant than the legal track, although the legal track was important, because the country they kind of got all this information. And after our grand jury appearance, the president acknowledged, as he had very carefully in his grand jury appearance, wrongdoing, and he apologized for it. And he kept apologizing for it. But it was out there. And I think the fact that he was not seen as a hypocrite, he was seen as somebody genuinely concerned with, the welfare of his constituents. And he kept right on working. He very wisely said, basically, he very wisely decided to kind of let the others do the talking for him. He was not going to attack. He was just going to keep on keeping on. And then I think the Starr report was a terrible thing. I think in some ways it backfired just by its excessiveness. It really was not necessary at all. And when the oohing and ahhing was over, people said, well, gosh, he's admitted this. And, Lewinsky, who was forced to testify, and she, again, to her, I think, unrecognized credit, really was truthful throughout. Her proffer through her lawyer, Bill Ginsburg, made in February 8th, as I recall, of 98. We got it later, of course. Stood up. I mean, that she said it then. She said it throughout. And in her grand jury testimony, when you read through supplements to the Starr report, you see that at the end of her testimony, a grand juror asked her, Monica, is there anything else you'd like to tell us? And she said, yes. Can we get these people out of the room? Meaning the Starr prosecutors.
Amazing. Yeah.
And she said, basically, nobody has ever asked me to lie or promised me anything for my testimony. That was it. And they'd spent days on the salacious details and they hadn't done anything. And I think that percolated. Then I think the president's, when they played the tape of his 4-hour interview, there've been kind of misleading reports of that he lost his temper and things like that. And he hadn't, but we'd been able to control the viewing of the tape. We negotiated his testimony in August a lot, and we finally got most of what we wanted. But one of the things we wanted was to have the White House unit do the filming and keep it in a tight focus on him. And he'd been able to really tell his story there. I mean, we recognized that in the grand jury, normally, of course, lawyers are not present. Everybody knows that. Everybody on this podcast, I think, knows that. But one of the things we bargained for was a short term, 4 hours on the clock. They wanted 2 days. And so I said, no way. They'd subpoenaed him, and I wanted the subpoena withdrawn, which they did. And then we knew that they were going to use the broadcast. I didn't want it taped, and I lost on that, but I got the White House to do the taping. And then there was a date question. The only things they were absolutely strong on were doing it in August, because he was just about to go on a very important overseas trip, and getting it taped. We got him to do it at the White House. We got him to have the lawyers present, which was very important. Chuck Ruff and I and my colleague Nicole Seligman were all there sitting at his elbow as he testified in the grand jury, which, again, lawyers out there know that doesn't happen.
It does not.
But the important thing for me was the withdrawal of the subpoena.
Why?
He appeared voluntarily. And because his appearance was voluntary, and I knew that we were going to have to admit in an abstract, non-privacy invading way, improper relations with Ms. Lewinsky. And I knew that they would want to dig in and try to get the scandalous details.
Right.
And we'd had knowledge of what they would do at the grand jury indirectly, and I knew where they were going to go. I wanted to cut that off. And the way to do that was not to do a contempt motion in the grand jury. It was to give them enough that they would have what they actually needed, but not anything that was embarrassing or scandalous. And so we worked it out with him that he would, I didn't put this even on email, but Nicole and I and the president worked out a short statement that's there in the record. And that was all he was going to say. So I knew that if they wanted to get more from him, they would have to issue a subpoena. We would fight the subpoena, and we would say all they want is scandal.
I see.
And I thought we had a very good grand jury judge. She was tough. But she was good. And I thought, she's not going to like that. So when it came time for him to testify, which I recall, I think it was on August 8th, they were going to come at noon. And so when they arrived, I said, and we're going to begin at 1. And I went down, I knocked on the door where they were, and there were a lot of them. And so I said to whoever answered, I said, can I talk to Mr. Starr? And they got Starr. And then we walked down the hall. They were in the map room. And so I walked down the hall, and there's the library of the White House. So go into the library. There's nobody there.
Wow.
And I say, there had been press. This was on a Monday. There had been press on Sunday about what great respect I had for the independent counsel. And this was a fight between two lawyers who respected one another. And I didn't know where those quotes came from. They didn't come from me. And so I said, Ken, I want you to know that all those nice things I was supposed to say about you, I didn't say any of them.
That's great.
And he laughed, and he said, I didn't think you did. And then I said, look, we're going to have, when you get to critical points about the relationship with Ms. Lewinsky, we're going to have a statement. The statement will give you what you need. We're not going to answer any other questions outside that statement on this particular issue. You can ask him whatever else you want, and that'll be fine. And he said, well, okay. When we get to that, I'd like to take a break after we hear the statement. And I said, fine. Because the deposition was going to be on the clock for us. That was one of the things they got. None of this long, 5 minutes, and then 25 minutes later, you're back on the record. So that's what happened. And they did it very early. And he said, I have a statement here. He read it, and they took a break. They came back, and they tried to go around it. And, President wouldn't answer. He said, I'm standing on my statement. And they didn't get more. And they didn't come back.
Fascinating.
They did not come back.
So much to unpack there. I will say when I was at Williams and Connolly, my office was next door to Nicole's, Nicole Seligman. And I loved her. She was so great, such a great lawyer. And it must have been great to have her on the team with you.
Absolutely brilliant. I got into trouble because this is years before, she'd accepted a job at Williams and Connolly. She was clerking, I think, and she was sort of on an R&R break. And I recruited her to work on a libel case involving the movie Missing, which was about Chile, the coup in Chile. And it was a great case. We were representing Costa Gavra, the director, and Universal that made the movie. And, there's going to be trips to Paris and everything. And also some complicated legal issues because we were defending for the first time a docudrama where there is falsification, invention of dialogue, characters, scrambling of chronology. And I knew that she would be perfect for that. She would love it. So I called her. She said, that'd be great. So day one, she hits the firm. And she said, well, I'm about half of my time is going to be taken up on this case. And so the lawyer kind of supervising traffic said, well, the fix is in. Kendall has done this evil thing. So I had to kind of promise not to ever do that again with any other associate coming on. So, but she was terrific, just first rate.
You mentioned Lewinsky sort of kicking them out and making that statement. I mean, she was also such a unique character compared to Linda Tripp, who was such a villain. I mean, she refused under tough circumstances to get wired up and to go under, pretty amazing that she had the fortitude to do that.
I agree with you. And she was a tough cookie. Now, luckily, she was a tough cookie for about 7 or 8 hours. And then she had the foresight to insist on calling her parents. And her father got his lawyer, a guy, LA lawyer named Bill Ginsburg, involved. And Bill Ginsburg was, as far as I could tell, basically a very good malpractice lawyer, a medical malpractice, but not a criminal defense lawyer. But he was a tough hombre. And he absolutely shut them down, said that they were not going to talk to her. He was going to go there. And so Ginsburg, he infuriated Starr. Starr really, really didn't like him. And I could never figure out what that was about. Ginsburg got a bad reputation as being on all the shows. For a time, there was something called Doing the Full Ginsburg, which if you're on 4 shows, in the morning, it's Sunday morning. Now with cable and the internet, the 4 shows are not so important. But in any event, he took the heat, and she was tough. And as I said earlier, consistent in her testimony. The thing about wiring Starr, it's funny. She said, "No way, I'm not going to do that. I'm not going to, talk to." And Starr denied that then later. And when he testified before Congress, it was one of these things that is quasi-legal because the House Judiciary Committee is holding in November of 98. They're now talking about impeachment, and they've had witnesses on legal issues. But unlike the Nixon impeachment back in, 74, 73, 74, they'd done no work. The Judiciary Committee did zero work. They accepted everything Starr had done. And then their only witness, because we kept waiting, where can we, I examine the witnesses the way Nixon's counsel had done in the 74 proceedings of the Judiciary Committee. There were none.
Right.
except Ken Starr testified. He was the only witness. So he testified on this full day of testimony. I was supposedly getting half an hour to cross-examine him. And there's no way I could do that job in half an hour. But unfortunately, I didn't know how much time I was going to have. I thought they would not limit me that. When the half an hour point was reached, Henry Hyde gave me another half an hour. But I remember one of the things, I was aware that Starr kept denying that they'd ask her to wire up. And so I decided to use his dislike of Ginsburg to kind of try to trap him. And so I said, now, Mr. Starr, and by the way, he began calling me David.
I saw that in the crossing. I saw that. And in fact, I was going to point out the very beginning of the cross-examination, David, you say you only have a half an hour, and you say, Mr. Starr, good evening. And he responds, good evening. How are you, David? And I'm very well, Ken. And everybody laughs. I mean, what a way to start the cross.
Well, the laugh was, I think what I said as sarcastically as I could. And then it was always back to Mr. Starr. He was David until I would get close to him. When I knew I was making headway, when he revert to Mr. Kendall. Mr. Kendall, I don't think that's fair. Mr. Kendall, how can you say that? Mr. Kendall. So on this one, I said, and I was called Mr. Starr. I said, Mr. Starr, Ms. Lewinsky's counsel, Mr. Ginsburg, has written in a Time magazine article in February or March of '98 that you asked his client to be wired up and talk to the president. He erupts. Mr. Kendall, I don't see how you can say that. Mr. Ginsburg is not known for his accuracy. I don't see, these are not the lofty proceedings I thought they were going to be if you would cite Mr. Ginsburg. So I said, Mr. Starr, do you know what an FBI 302 is? And there was a pause, and I swear to God, I could see him deflate because he was on his high horse about Ginsburg. Wow. And the 302s that we had documented her time when she was being held. He denied she was being held. I used the term sojourn. I said, okay, well, I'll use the term sojourn with you.
He hated that you said held.
I led him through it, and his tone and demeanor were just deflated. Because I said, well, then it says this, it says that. And, these are your trusted FBI agents. No reason to think that's false, do you? So that was the thing about her being, very tough and giving me a line on him, because this was in the impeachment argument before actual impeachment, and all I wanted to do was draw. If I could draw him in public, because this was what the public were seeing. This was, I think it was on prime time. I remember it started about 8:30, went to 9:30 in the evening, but it was a tense, and I had it's unlike a cross-examination in court. I had a guy chairing it who would hit me with a gavel if he could have and gotten away with it. So I had no friends there.
I also saw you went after him about the leaks. What was that all about? Why was he so defensive, and why did you go after him about that in your time?
Well, I thought, and again, I'm sure that some of your audience can sympathize with this when you have the press reporting, and I've represented a lot of reporters. I've represented the Washington Post a lot. I know that's their job. But when they're reporting stuff from inside the grand jury, it is uniquely prejudicial. It's violative of the whole theory of the grand jury. And so it's just, I find it offensive in any case. And it's not necessarily what independent counsels do. Special counsel Mueller, I thought, ran a leak-free investigation. I mean, he laid down the law early. He's a prosecutor. Starr early on said there's going to be no leaking. And one of the things I tormented him with was his statement about that. And then, the way the media sourced it was a source in Ken Starr's office tells us. So we had a battle we had a battle in the 6E proceedings, which were all sealed. I got the court to order his deposition on the leaks, but the Court of Appeals in a sealed proceeding reversed that and said they had to appoint a master to do that. So anyway.
So, and David, talking about the grand jury and Clinton's testimony, I mean, there was a lot of criticism, of course, about, him trying to parse certain things and be legalistic. And I saw your defense of it. Like, why shouldn't you be legalistic and why shouldn't you be precise? And that was, I watched your presentation in the Senate, and you gave a great defense about, it is important to be precise. It is important to be legalistic. Do you think it was unfair criticism of the president?
Well, let me say this: the term perjury was what the
right
Congress was supposedly investigating. If you're going to put politicians on trial for the accuracy of their unsworn statements, you're not going to have many people in Congress or the Senate.
Right.
My defense was that he did not perjure himself in the Monica Lewinsky deposition. He certainly didn't do it in the grand jury testimony where I was doing. And because they'd used such a vague definition in the Lewinsky case, they were, I think, embarrassed about it. So they used a definition from in sexual harassment cases. And he, when you work it out, and again, civilians don't understand this, but when you work it out, he didn't perjure himself because oral sex was not encompassed in that deposition. And that's why I was convinced that if it ever came to a criminal trial, we would have a good defense.
I saw also during your Senate presentation, you were using those big blow up boards that we used to use, the old school big blow ups, which I really liked. Now everybody's using, electronics and PowerPoints. What do you think about using those kinds of visual aids in a trial? I mean, this was a different sort of trial, but the same principles apply. How important is that?
Well, it depends on the issue. I think sometimes visual is very important. If it can be simple, if it can be a chronology, or if it can be, something that's just boiled down. If it gets complicated, it loses its punch. I also think the problem with the electronic stuff is you can't go back to the jury usually. I think if you've got a good demo, and by the way, we didn't have any demos. Those were all the White House managers. There were 13 White House managers. They were all their stuff. So I thought that it was. I sometimes would ask them to leave it up. Representative Hutchison, former Governor Hutchison, I used some of his charts, I remember, to make different points. But so I think it depends. I think visuals are important. I think demonstratives are important if you do it right. You can't do it too much. It's got to be dramatic. It's got to be something that clicks in the mind.
Of course, this was the Senate trial, which is not the kind of trial we're used to, where different rules, or some people say no rules, apply. How do you prepare for that? We're trained with the rules of evidence. We're trained with the rules of procedure, and you're thrown into a Senate trial where a lot of those things are they don't apply.
Well, it's true, and we prepared as best we could. The White House team were basically trial lawyers, Chuck Ruff, others, Lenny Brewer. We decided we would try to do this, try to keep out hearsay, try to keep out extraneous stuff. And we worked a deal through Tom Daschle, who's really talking to us. Another thing that was odd about the Senate is in a jury trial, of course, you can't talk to the jury. Here, we were talking to our group of jurors all the time, as
right.
with the White House manager.
Good point,
so
right.
You're talking to jurors. But we got Senator Daschle to make the other side agree that the only evidence that could come in was contained in the Starr volumes, because there were a lot of rumors circulating and they'd get out there. So we said, look, that's got to be the evidence, nothing else. And they agreed on it. The other side, because I think the Republicans in the Senate, they'd seen how the midterm results went. There's a lot of antagonism to the House of Representatives in the Senate. It will not surprise most people to learn to know about this. And so they thought that these people are undisciplined. They haven't done their work. They haven't done their evidence. Now they're coming over here wanting to do discovery and all that. So we had that. Also, the very first day of the trial, I'm trying to think how this happened. One of the Democratic senators stood up to object to the presentation of one of the managers, I think Bob Barr from Georgia. And the objection, I think it was Tom Harkin of Iowa, if I'm right. made a very good objection. He said he's suggesting that, this body is not the judge of the facts and the law, and therefore, and he went on. So then Barr objects that he's making a speaking objection. Well, Rehnquist, the Chief Justice, who's denominated to sit as the judge, made what, in my mind, was a Solomonic ruling. He said, I sustain the objection to the comments. The Senate is the judge of both law and fact, like a jury. But I also sustain the objection to the speaking the objection to speaking objection. And so it was kind of one of those decisions that let both sides know I, William H. Rehnquist, am in charge here. And that was the way. Well, he was good. I thought he ran a good ship. He ruled, and both sides, I think, were a little embarrassed, didn't want to be embarrassed in the public by his ruling against him. He had a lot of credibility.
So, David, I interviewed former President Trump's lawyer about his trial, and infamously, they would eat McDonald's during lunch during Trump's trial. What did you guys do for eating during these long days? You guys were in trial for a long time before the Senate. Did they bring in food for you? How'd you do it?
David, I honestly forgotten. I remember, I think they brought in sandwiches, because I remember on breaks eating a sandwich. I don't remember.
No McDonald's? No McDonald's for you?
Definitely no McDonald's.
And what are you like during trial, David? Do you exercise and eat during trial, or are you just 24/7 working?
Well, I like to exercise because I'm used to it, and it I think helps me sleep. Anxiety is, of course, every trial lawyer's enemy, and you deal with it as best you can. I eat, I drink a little bit, not very much, but and I try to stay in shape, but I do focus, and I find that often, in the shower, I think about things, I plan. So I can't say it's a 24/7 job, but except when you're asleep, it's probably what you're doing, even when you're exercising or eating.
I have to say, during the Trump impeachment proceedings, I was really surprised to see Ken Starr pop up and make some of the arguments that you were making against him during the Clinton impeachment. You must have been going crazy.
Well, he's died. I don't want to say anything, unduly negative, but his testimony speaks for itself.
Yeah, well, that's true. Now, of course, you end up winning the Senate impeachment trial, but just the process itself, and we often talk about this as criminal defense lawyers, right? Like the process itself is just such a killer on the client. Do you guys celebrate? Like, what do you do after you win that trial?
Well, we had a rule, and I can't remember if it was me or Chuck Ruff. One of us, or maybe both of us, said, no gloating. This is not something to gloat about. We're going to not. So we made a practice of not having a celebration. And I remember a reporter whose name we'll go unmentioned offered to buy me lunch. And I said, no, I can't do that. But I said, I'm sorry, because I would love to have you pay for lunch for me, but yeah. I'm not going to do that. So we tried to just low key it. And I think the country was kind of sick of it, frankly.
Right.
Sure. I think everybody wanted to get beyond it. They formed their opinion of all the dramatis personae. And so then we just, went on about our business. And he had not gotten obsessed with this. And he really was trying to focus on doing other stuff. And I think that was helpful.
And of course, you continue to represent the Clintons for many years, still representing them in a proceeding that you and I are working on together. And you're still very close with the Clintons.
I am, I was disappointed for a number of reasons when Judge Cannon dismissed the Florida indictment, because I have a small role in that indictment. If you look at paragraph 55. It's dealing with the conspiracy allegations, and it's quoting President Trump saying, and this is, I pretty much got it right. Check me in paragraph 55. Brackett attorney, that would be Kendall, did a good job. He did a really good job. He went out and destroyed the documents for Hillary, those 33,000 documents. Then he took he acknowledged that he'd done that. He said they were just gym and luncheon and private stuff. But he stood up. He really did a good job, and she didn't get into trouble. Now, they use that to show that he's urging his own lawyers sitting there with him to go out and destroy some of the classified documents. But I thought, is this a compliment or not? I can't decide if it's a kind of bad, because it's a distortion of what I'd done. I mean, that we were producing, official business government documents to the State Department pursuant to a voluntary request. And indeed, we produced way over, I've forgotten the exact number, produced way over 33,000 documents. And they returned about 1,000 documents saying these are not government records. So we erred on the side of producing what they wanted. But I thought, I didn't expect to get a backhanded compliment from Donald J. Trump. If it's a compliment, I'm not sure it is.
That's great. It's interesting because in a number of the Trump cases, they're using like lawyer notes, voice notes against him. I think you had been quoted during some of the representations of the Clintons that you didn't want folks taking notes during the meetings and so on. Tell me about that. Are you a believer in note taking as lawyers, or we shouldn't be taking notes?
Well, again, I hate to say it, but I think it depends. I do think lawyers' memories, and now I'm 80 years old and my memory is not so Velcro-like as it once was. I do think it's important to take notes, your own notes, making sure that it's simply reflecting what is said, not so that you're trying to just remember the facts correctly. People's memories change. So I think some note taking is desirable. I think it's often useful to have those notes typed, but in a busy case, who can do that? You just can't do that. So I keep handwritten notes. And I tell my team, look, I don't want the wrong, if people are speculating, don't write that down.
David, yeah, go ahead.
Yeah. So, but I can't control the reason I was, vehement about others in the White House taking notes. They're not necessarily under the privilege. And I don't want them taking notes of something that I'm involved in.
You say your memory's not good. You were rattling off for the past hour plus dates, times, people you interviewed, remembering cross-examinations. Your memory at 80 is better than most people at 20. It's unbelievable, David.
Well, this stuff was burned. Again, a lot of defense lawyers, I think, have this. The clients forget a lot and they're vague. But the defense lawyer, this stuff is burned into you because you are that anxiety at bedtime in the shower. You just live with it. And so a lot of stuff you remember. If Ann were to ask me, what did we do the week of Easter, 1998, I couldn't begin to tell you.
The week of Easter is the time period surrounding Easter Sunday. Which
you got your Alexa going. You got your Alexa going off there.
Alexa, stop. What did I say to merit that?
I don't know, but I will say, you're still practicing at 80 years old. I love it. Are you ever going to retire? You're still going to go?
Well, I think, again, it depends. I have grandchildren ranging from age 3 to 16. 4 of them, thank goodness, are in DC. The other 2 are in Brooklyn, not far away. I spend a lot of time with them insofar as I can. And luckily, my children and their spouses have not learned that they could charge me for taking care of them. And so they're not charging me. And Ann and I like to travel. And my wife and I were married in 1968. We still, are out and about. So, but I work. I mean, I've always worked. I love work. And now I can be more selective. I have a wonderfully supportive law firm. They've always treated me fairly through thick and thin. And so I kind of enjoy the stuff I'm doing now. I mean, the case we have is a civil case defending against civil RICO charges brought about the 2016 election. That's one which I find interesting. I find some other, cases interesting. I'm increasingly doing pro bono stuff as well. So I don't, retirement is like a 4-letter word to me somehow.
I love it, David. Well, I just want to thank you for spending the time with me, sharing these stories. We could have talked for days and days and days. We talked about as long as your cross-examination of Starr, which I love. So thank you so much for doing this, and it's great to remember those days in the 90s.
David, thank you. It's been a pleasure. I am sorry you left Williamson Connolly to go to Miami, but c'est la vie.
Yes, sir.
I know I say this a lot on the podcast, but I really could have spoken to David Kendall for many hours about that time period, about the Clinton impeachment proceedings. What an incredible case, what an incredible representation, and the stories truly amazing. I want to thank David Kendall for taking the time to speak with me about the case, for sharing those stories. Truly incredible. Thank you, David. We'll be back in a couple of weeks on another episode of For the Defense. Thanks again.